Hello and welcome to the first video of Ninox Law, your lawyers to care for country, community and the environment. I'm Sean Ryan, Principal Lawyer at Ninox Law. One of our amazing clients is Save Victoria Park. They're trying to protect the historic Victoria Park, which has been called the green lungs of Brisbane City. They've asked us to help explain some of the proposed laws that are currently before the Queensland Parliament to assist you in deciding whether to make a submission to the Parliamentary Committee before 20 May 2025. So today we'll be unpacking the Planning, Social Impact and Community Benefit and Other Legislation Amendment Bill, the POLA Bill, and why it might be one of the more radical shake-ups to planning and environmental law in Queensland's history. Let's start with some fundamental legislative principles. Fundamental legislative principles are the principles that underline a parliamentary democracy based on the rule of law. These include the rights and liberties of individuals and the institution of Parliament. But what is the rule of law? Well, once upon a time, kings ruled the land and they ruled by decree, and their word was the law, and everyone else had to obey. Everyone except for the king, of course, who could tax, imprison, and seize land without due process or review. Eventually, some barons got together and stood up to the king and said, "Why is it fair there's one law for you and another for the rest of us? How about we all agree to be bound by the same laws? Like the laws are the rulers, a rule of law." And that idea today, the rule of law, is a cornerstone of modern democracies. For example, the Planning Act, the Queensland Heritage Act, and the Environmental Protection Act apply pretty much to everyone in Queensland with some limited exceptions. They certainly apply to you and me if we were to build a shed in our backyard or demolish an old Queenslander. So what does this have to do with the POLA Bill? Well, the Queensland Government already does have an act to fast-track Olympic developments. It's called the Brisbane Olympics and Paralympic Games Arrangement Act of 2021, or Olympics Act for short. But now, the POLA Bill seeks to amend the Olympics Act and go much further. It proposes two key new sections into the Olympics Act. Section 53DC sets the scope, and 53DD does the heavy lifting. Section 53DC says the law applies to development that is for the construction of an authority venue, other venue or village for a games-related or legacy use. Venues and villages are listed in the new schedules to the Olympics Act. For example, a stadium in Victoria Park is an authority venue. Victoria Park is a 64-hectare parkland under 1 kilometre from Brisbane CBD, and it holds a rich colonial and pre-colonial history. Preliminary designs for the stadium and villages in Victoria Park include commercial and residential development along Hurston Road. No villages are yet listed in the schedules to POLA, which will amend the Olympics Act, and the villages are not shown in the images accompanying the government's announcement of a stadium in Victoria Park in March of this year. But the explanatory notes to the bill say the villages will be listed after detailed design is complete in about 6 months' time. And the Courier Mail reports that it is an open secret that the sale of residential towers in Victoria Park will be used to help pay for the Olympics. Now, if a stadium in Victoria Park is an authority to venue, Section 53DD then applies. What does 53DD do? It declares the development lawful despite 15 key acts. These include the Planning Act, the Environmental Protection Act, and the Queensland Heritage Act. In short, a backyard shed or a house renovation must comply with Queensland planning laws, but a declared Olympic stadium does not. Now, we all love the Olympics, but recall that those exemptions also apply to a village that has privately developed residential towers on public parkland, in which case the exemption from planning and environment laws could have considerable commercial value. If these towers are privatised, as reported in the Courier Mail, then how will Queenslanders be ensured that they receive value for money from the sale of their public assets? Close attention would need to be paid to safeguard against corruption, where there's a potentially significant transfer of wealth outside the normal checks and balances provided for by these 15 laws. That brings us to part 2 of this talk, separation of powers. As the saying goes, power tends to corrupt. Absolute power corrupts absolutely. To guard against corruption, our forefathers divided power into 3 branches: the legislative, our elected representatives who make the laws; the executive, our police, military and bureaucracy that implements the laws; and the judiciary, our judges who interpret the laws. One of the key roles of the judiciary is to ensure that the executive stays within their lawful limits, i.e. within their jurisdiction. This process is called judicial review. But sometimes governments pass legislation to block court oversight. These are called privative clauses. An example is Section 53BB of the current Olympics Act, which says decisions are final and cannot be challenged in any way by any court unless affected by jurisdictional error. That caveat comes from a case, Kirk's case. In Kirk, the High Court said that the state Supreme Courts must retain constitutional authority to review for jurisdictional error. Otherwise, it would create islands of power immune from supervision and restraint. Because this function comes from the federal constitution, it cannot be overridden by state legislation. Now back to the POLA Bill. Section 53BB would be repealed and instead replaced by 53DD, subsection 3, which states, no proceeding may be started, a civil proceeding, if it would delay the timely delivery of a venue or village. This seems to block even judicial review remedies if they would delay the Olympics, potentially limiting the court to a naming and shaming declaration, not an injunction or any corrective relief if it would delay the Olympics. Is this consistent with the principles in Kirk's case? It's certainly very difficult to reconcile. The High Court warned against creating islands of executive power immune from judicial restraint. To wrap up, aside from community concerns about building a stadium in Victoria Park, the POLA Bill raises serious constitutional issues. It potentially undermines the rule of law and threatens the separation of powers. These are 2 fundamental safeguards against corruption. By exempting Olympic developments from 15 of Queensland's planning and environmental laws and shielding it from the review powers of the Supreme Court, it risks creating an island of power where massive transfers of wealth could occur without the usual safeguards against corruption. If you're concerned about the provisions of the POLA Bill, you can make a submission to the Parliamentary Committee before 12 noon on the 20th of May this year. Be sure to include your full name and at least 2 forms of contact. Details on how to make a submission can be found on the committee's website. Thank you for watching. If you found this explainer helpful, please like, comment and subscribe for more community legal explainers like this one. You can check out our website for a full text explainer, which this video is based on, or check out Save Victoria Park to learn more about our client for this video. Till next time, take care.